On a Friday night in May 2026, while most Americans were finishing dinner, a federal court in New Orleans quietly issued an order that nearly ended mail-order abortion pill access across all 50 states. By Monday morning, the Supreme Court of the United States had stepped in, and by Thursday, the 9 justices who sit at the highest court in the land were openly divided. This case has it all: states' rights, federal power, a 153-year-old obscenity law being resurrected from the dead, and 2 of the most conservative justices on the Supreme Court publicly breaking from their own colleagues. But here's what the headlines aren't telling you. The left and the right are both only giving you half the story. Today, on The Right Whisperer, we are going to give you both sides, the full law, and let you decide. Before we get into what the courts actually said, let's talk about what people across America are actually arguing about. Because depending on which side of the aisle you sit on, this case looks completely different. Here is what conservatives and the right are saying. They argue that the 2022 Supreme Court decision in Dobbs versus Jackson Women's Health Organization, which overturned Roe versus Wade, was a promise to the American people. The promise was simple. The authority to regulate abortion goes back to the states, back to elected representatives, back to the voters, not to federal bureaucrats in Washington, not to the FDA. Louisiana's position is exactly that. They say, we passed a strict abortion ban. Our voters supported it. Our legislature enacted it. And yet, out-of-state doctors are prescribing abortion pills over a video call and mailing them directly into our state, completely bypassing our law. Conservatives argue this is not a healthcare access issue. It is a sovereignty issue. If a state cannot enforce its own laws at its own borders, Dobbs was meaningless. There is also a religious and moral dimension. Many on the right view Mifepristone not as a neutral pharmaceutical, but as a drug specifically designed to end a human life. To them, the FDA allowing it to be mailed freely is the federal government actively participating in something they consider morally and constitutionally wrong at the state level. And then there is the Comstock angle. And we will come back to this because it is explosive. Now here is what progressives and the left are saying. The left argues this is not about states' rights at all. It is about a small number of conservative states trying to reach beyond their own borders and restrict access to a federally approved medication that is used in 2 out of 3 abortions in America, and also used in miscarriage care, treatment of certain cancers, fibroids, and endometriosis. They point out that the Fifth Circuit's ruling did not just affect Louisiana. It affected all 50 states, including states where abortion is completely legal, where voters have voted to protect abortion rights, where state constitutions enshrine reproductive freedom. A woman in rural Montana, in a state where abortion is legal, would have had to drive nearly 250 miles to a clinic just to pick up a pill in person that she could have received by mail the day before. The left also points to the science. Mifepristone has been FDA approved since the year 2000. Decades of safety data support it. Over 100 peer-reviewed studies have examined it. The FDA's own conclusion, reached after extensive review, was that in-person dispensing requirements were medically unnecessary. Their argument is simple. This is not a debate about safety. It is a coordinated legal strategy to make abortion as logistically difficult, expensive, and unreachable as possible, one court ruling at a time. So who is right? That is exactly the question sitting in front of the Supreme Court. And to understand how we got here, you need to understand the law. Because what happened inside one federal courthouse across a single weekend almost rewrote the rules for every American in every state. And 2 sitting Supreme Court justices are on record saying they wish it had. Here is exactly what went down. Let's break this down cleanly. Mifepristone, FDA approved since 2000, used in combination with a second drug, Mifepristone, for medication abortion and for miscarriage care. As of the latest available data, this 2-drug combination accounts for roughly 2 out of 3 abortions performed in the United States. For over 2 decades after approval, Mifepristone carried strict requirements. Patients had to receive it in person at a clinic, hospital, or certified medical facility. No mail, no pharmacy pickup. You had to physically be there. During the COVID-19 pandemic, the FDA loosened those restrictions temporarily. Then, in January 2023, through what is called a Risk Evaluation and Mitigation Strategy, or REMS, the FDA made those relaxed rules permanent. From that point forward, a licensed provider could prescribe mifepristone through telehealth, and the patient could have it delivered directly to their door or pick it up at a certified pharmacy. In October 2025, the state of Louisiana filed a federal lawsuit under the Administrative Procedure Act, the APA, challenging the FDA's 2023 REMS modification. Louisiana's legal arguments were two-pronged. First, that the FDA's decision to loosen the rules was arbitrary and capricious, meaning the agency did not follow proper legal procedure. Second, and more importantly, that allowing out-of-state telehealth providers to mail mifepristone into Louisiana was actively destroying the state's ability to enforce its own abortion ban under Dobbs. Louisiana was not bluffing. In January 2025, the state had already issued the first criminal indictment of an abortion provider since the Dobbs decision, targeting a New York physician accused of prescribing abortion pills by telehealth to a Louisiana teenager. And the state pointed to approximately $92,000 in Medicaid costs it claimed to have paid in 2025 for two women who needed emergency care after receiving mifepristone mailed from out of state. The federal district court in western Louisiana heard the case. In April 2026, that court sided with the FDA, not on the merits, but procedurally. It agreed to pause the entire case while the FDA finished its own internal safety review of mifepristone, a review that had begun back in September 2025. The court gave the FDA until October 2026 to file a status report. Louisiana did not wait. Louisiana immediately appealed to the United States Court of Appeals for the Fifth Circuit, demanding emergency relief. On May 1, 2026, a Friday evening, a unanimous three-judge panel granted it. The order was immediate and nationwide. In-person dispensing, reinstated. Telehealth prescriptions, ended. Mail delivery, ended. Pharmacy pickup, ended. In every state, not just Louisiana. Providers scrambled. Pharmacies pulled prescriptions. Patients with existing telehealth orders suddenly had no legal way to receive them. The chaos was immediate and real. And then the drug manufacturers did something that sent this case straight to the top of the American legal system in under 24 hours. And what happened at the Supreme Court revealed a fracture that could define how this court rules for years. That same Friday night, the manufacturers of mifepristone, Danco Laboratories, which makes the brand name version called Mifeprex, and Gen Biopro, which makes the generic, raced to court. First, they asked the Fifth Circuit to pause its own ruling. The Fifth Circuit did not respond. So by Saturday, May 2nd, both companies filed separate emergency applications directly to the United States Supreme Court. Their argument to the justices, this ruling unleashes immediate, irreversible chaos on a federally approved drug's established distribution system. Years of regulatory infrastructure cannot legally be dismantled overnight while a case is still being litigated. Under Supreme Court procedure, emergency applications from the Fifth Circuit go first to Justice Samuel Alito, who oversees that circuit. On Monday morning, May 4th, Justice Alito issued a temporary administrative stay, pausing the Fifth Circuit's ruling and restoring the status quo for 1 week while the full court reviewed the briefs. He extended that stay to May 14th. Then, 30 minutes after that second deadline expired, the full Supreme Court acted. The court granted a formal stay of the Fifth Circuit's ruling. Mail order access to mifepristone was preserved, for now, for the entire duration of the case through the Fifth Circuit and any future Supreme Court review. But the vote was not unanimous. Justices Clarence Thomas and Samuel Alito dissented, openly, on the record. Justice Alito, the same justice who had twice temporarily protected the status quo, turned around and dissented when the full court made it permanent. He argued the drug manufacturers should not be shielded from state regulations simply because compliance would hurt their profits. And Justice Thomas went further. In his dissent, Thomas explicitly invoked the Comstock Act, an 1873 federal obscenity law, writing that it is already a federal crime to ship mifepristone through the mail for use in abortions. The Comstock Act bans using the postal system to ship any drug designed for producing abortion. Thomas argued Louisiana's claim was supported directly by this still active federal statute. This is not a minor footnote. If a majority of the Supreme Court ever adopts Thomas's Comstock Act reasoning, It would not just restrict mail-order mifepristone. It could function as a de facto national abortion ban without Congress ever passing a single new law. So where does this go? The Supreme Court stay keeps current mail-order rules intact while the case heads back to the Fifth Circuit for full appellate review, and then almost certainly returns to the Supreme Court for a final decision on the merits. Louisiana is not alone. Missouri, Texas, Idaho, Kansas, and Florida have all filed related lawsuits. Some are targeting the telehealth rules. Others are directly challenging the FDA's original approval of mifepristone, dating back to the year 2000. Federal courts across the country are already ruling in conflicting directions, which is exactly the kind of split that forces the Supreme Court to step in and settle the question permanently. Meanwhile, the FDA, under the current administration, is conducting what critics describe as a politically motivated safety review of a drug with over 2 decades of safety data. Notably, the Department of Justice filed no brief defending the FDA's rules when this case was at the Supreme Court. The agency that created the rule is not actively defending it. And in Congress, at least one sitting senator has already introduced legislation to revoke the FDA's approval of mifepristone entirely. This case is moving inside a political, legal, and legislative pressure cooker. All 3 branches of government are now involved. Here's the bottom line. The Supreme Court has temporarily frozen the Fifth Circuit's ruling. Mail-order access to mifepristone is intact, for now. But with Thomas and Alito on record dissenting, with the Comstock Act now formally in play, and with a divided FDA conducting a review of a drug it once defended, this case is far from over. This is what post-Dobbs America actually looks like. Not just state legislatures debating abortion laws, but emergency court orders dropping on Friday nights, the Supreme Court fracturing in real time, and a 153-year-old law potentially being used to end mail-order abortion access in every state in the country. I will be tracking every development as this moves through the Fifth Circuit and back to the Supreme Court. If this video gave you the full picture that the mainstream coverage missed, hit subscribe and turn on notifications, because when the next ruling drops, it will drop fast, and you want to be ready. This is The Right Whisperer. Stay informed. Stay sharp.